I'm John. I'm the event director at Literati Bookstore. We're pleased to welcome Carlton F.W. Larson to our At Home with Literati series in conversation this evening with Julian Davis Mortenson. First, a quick overview of our webinars. You heard me as you were joining us, but the chat is closed, although you may want to keep the chat window open during the event, as I will be dropping links to purchase On Treason from Literati. And there is a link in the description below if you are joining us later on YouTube. You can submit questions if you're watching live for the Q&A using the Q&A feature available to you at any time. And I'll read a selection at the conclusion of the conversation. But I encourage you to, as a question pops in your head, to please feel free to write it that moment in the Q&A, and we'll make sure to read those at the conclusion of the conversation. And a final reminder, you can also shop for more books at literatibookstore.com. Thousands of titles are available for curbside pickup if you live in Southeast Michigan. And in lieu of a book purchase, we'd also ask that you consider a $5 donation to sustain our virtual programming. So whether you'd like to think of that as this week's or this month's or this year's subscription to our programming, you can make donations at literatibookstore.com/donation. Otherwise, we simply thank you for your attendance this evening, or this morning, or this afternoon, depending on where and when in the world you may be joining us from. So without further ado, I'll introduce our author and moderator this evening. Carlton F.W. Larson is Martin Luther King Jr. Professor of Law at the University of California, Davis School of Law, where he teaches American constitutional law and English and American legal history. A graduate of Harvard College and Yale Law School, Larson is one of the nation's leading authorities on the law of treason. His scholarship has been cited by numerous federal and state courts and has been highlighted in the New York Times and many other publications. He's a frequent commentator for the national media on the constitutional law issues and is the author of the book, The Trials of Allegiance, Treason, Juries, and the American Revolution. And an engaged scholar and award-winning teacher, University of Michigan James G. Philip Professor of Law, Julian Davis Mortenson, specializes in constitutional and international law. His current book, Project, under contract with Harvard University Press, develops a comprehensive account of presidential power at the American founding. He's also co-authoring a new constitutional law casebook for Foundation Press. He is visiting appointments on the faculties of Cambridge University and the University of Tokyo. They can't hear you, but they can sense it through the power of the internet. So please join me in welcoming Carlton F.W. Larson and Julian Davis Mortenson into your living rooms.
Thank you so much for that kind and generous introduction, John. It's terrific to be here and terrific to share the stage with Professor Larson, somebody I've known for a long time and have overlapped with lots of different points along the way, and just wish that we were able to do this all in person. It's a real honor to have a chance to be in conversation with you on this book, Carlton.
Thank you.
I guess the first question that jumps to my mind is the why of the book. Why did you decide to write a book about treason, and why now?
Sure. First of all, let me just say a big thank you to Literati Bookstore for hosting this event. I really appreciate it. And thank you to you, Julian, for being willing to do this. Julian has a terrific book project he's working on executive power. He's one of the sharpest thinkers on this subject ever, and so it's going to be exciting when his book comes out. So why write a book about treason now? Well, this is a subject I've been interested in for a very long time. I actually wrote my college thesis on the subject of treason during the American Revolution. But it was one of those subjects that really didn't have a lot of contemporary relevance. Yeah, it was fascinating, it was historical, there was a lot there, but I didn't get phone calls about it, to put it mildly. And then Donald Trump came along, and I started getting phone calls from the media asking whether or not Donald Trump had committed treason. And this was pretty extraordinary, actually. People wanting to know whether the President of the United States had committed the highest crime known to the law. And as the calls kept coming in, I realized that there's a real sort of lack of understanding among many people about American treason law. And then Trump himself started displaying much of that same lack of understanding when accusing his own political opponents of being traitors. And so I realized also people are talking now a lot about the subject I've devoted a lot of my life to. So if not now, when? Why not write a book about treason law that is aimed not for lawyers, but really just sort of any interested American who wants to know more about what treason law is and also what it isn't, along with illustrations from its very fascinating past.
Terrific. I mean, you know, the book couldn't be more timely in terms of the arc of discourse over the last 4 years in particular, as you say. And I think in the back of many people's minds would be, assuming the allegations are true against Donald Trump, did he commit treason? And perhaps, you know, should we think, as Donald Trump suggested we should, about what Adam Schiff did in the course of the impeachment process as being potentially treasonous? We won't start there, perhaps. We should perhaps build our way towards that, a very large question. You know, you and I are lawyers. Lawyers like to start with the text of the document. In the first instance, your extremely learned and just gripping analysis of this subject begins with the U.S. Constitution and that provision of the Constitution that speaks to when, where, how treason can be committed. Tell us a little bit about that. What are the basic requirements in the definition of treason that are specified by the Constitution?
Yeah, so our Constitution is unique in that treason is actually defined specifically in the document. It's the only crime defined in the Constitution, and so that means Congress can't change the definition. It is what it is. And that definition is that treason against the United States is limited to, shall consist only of, to use the actual phrasing, levying war against the United States or adhering to their enemies, giving them aid and comfort. And so these roughly describe what you might call sort of internal or external treason, levying war against the United States, you know, essentially raising an armed force to overthrow the government, and then enemies, that is, you know, aiding the enemy, a foreign power or group during wartime. And that's really it. And so there's a whole range of other things that we might think of as disloyal behavior, but that just simply can't be punished as treason. That's going to be punished as something else.
So I want to explore both of these definitional paths with you. What is levying war? What does it mean to provide aid and comfort to the enemy? What are the alternatives if something's not treason? I was struck in a big way by your review of the background to the English statute, which is the predecessor to the American Constitution's provisions on treason. It turns out in your account to have a role and a function in English law that's quite different from what at least I would have expected approaching this material for the first time. What did the English statute dealing with treason do, and why did it do it?
So in 1351, Parliament enacted the Statute of Treasons, which limited treason to a number of distinct offenses. The core of it was compassing the death of the king, but it also included phrases that are familiar: levying war against the king and his realm, or adhering to the king's enemies, giving them aid and comfort. Our framers took that language directly from the English statute. And so the question is, well, why would the English Parliament feel a need to limit the crime of treason in the middle of the 1300s? Well, like many things, it all goes back to money, and it goes back to inheritance. And it turns out that there was a distinction in English law determining if you were convicted of treason versus being convicted of an ordinary felony. And if you're convicted of an ordinary felony, your lands would forfeit to your next highest lord in the feudal chain. But if you were convicted of treason, your lands would forfeit to the king. And so that meant that, you know, wealthy nobles would lose out if treason was defined broadly. And the king would potentially benefit if the crime was defined broadly. And so Parliament, being composed of largely, you know, wealthy nobles, sought to limit this crime in order to protect their ability to seize the lands of convicted felons. Now, we no longer think of crime really in those terms, and later English scholars sort of said, well, it had, you know, broader liberal instincts about protecting the citizen from arbitrary treason prosecutions. But really, the initial motivation was about this money problem and land problem.
So from a money problem, Parliament enacts a statute limiting the scope of things that can be prosecuted as treason, in substantial part, as you describe it, simply to protect the coffers of the wealthy landowners, and sort of cabin efforts by the king to classify lots of stuff as treason so as to enrich the crown. As your book suggests, though, and describes, that's not how the American revolutionaries understand what the statute does. And that's not how sort of the 18th century Anglo-American legal community understand the statute? What's the transmutation that happens from this initially property-oriented, arguably self-protective statute for the wealthy landowning class? What's the story about getting from there to being embedded in the Constitution as a protection of liberty?
Well, I think you have a handful of things. You have a series of expansive treason statutes during the reign of Henry VIII that were later viewed as a significant mistake and as a departure from the original English statute. You have a series of treason trials prior to the Glorious Revolution in England in the late 1600s that were later seen as a significant mistake. And so by the 18th century, you really do have sort of an Anglo-American understanding of treason as a crime that needs to be carefully limited. That if you don't limit it, it is subject of significant governmental abuse. And so the framers of our Constitution, they shared that general understanding in the 18th century world, but they also had sort of particular grievances, and that was that they themselves have been accused of being traitors in the lead up to the American Revolution because of their activities as tax protesters. And they deeply resented that and thought that that was sort of an unfair reading of British law. And so by writing this in to the Constitution, they really sought to protect individuals against abusive treason charges.
Did they have much experience with the question of treason during the rise of conflict and hostilities that culminated in the Revolution?
Yes, hugely, and that's actually the subject of my first book, The Trials of Allegiance. So during the Revolution, but essentially everybody was potentially a traitor. That is, if you remained loyal to Great Britain, you were a traitor to the nascent American states. If you were loyal to America, you were a traitor to Great Britain. And so the criminal law of treason potentially hung very heavily over the lives of many Americans who had to confront these difficult questions of loyalty, which was then potentially enforced through the criminal law. So it was something that they had lived through as a really sort of a defining period of their lives.
So it's interesting. You're describing what could be, at least in the American Revolutionary context, thought of as essentially a political question, right? How does the citizen conceive of his or her identity? To whom does the allegiance run? And yet we start from that sort of political pressure and emerge with a set of pretty hard-edged legal definitions of what it means to commit treason. Take us back to that. Well, what are the core elements of treason? What are the things that have to be satisfied in order for someone to have committed treason as specified by the Constitution?
Okay, so for levying war, part of the problem is that the decisions on this are all quite old. There are no federal decisions on the meaning of this since the 19th century. They suggest that you have to have an assemblage of men on the view that only a group of men can wield force, whereas an individual really cannot, and that assemblage of men has to then use force in some way to try to overthrow the government. The older cases suggested simply overturning one particular law would be enough. That was an issue in the Whiskey Rebellion, for example. But the later cases suggested it really does have to have sort of the intent of overthrowing the government entirely. For aiding enemies, an enemy has to be a foreign nation or group with whom we are in a state of open war. And that creates a very limited range of people. At the moment, I think that would include Al-Qaeda, it would include the Taliban, it would include ISIS, but probably not much more than that. And then there's a further problem that in order to prove treason, you have to have two witnesses to the same overt act. And this is also a requirement in Article 3. So unlike any other crime, this is the standard. And this was new in the U.S. Constitution. English law said you had to have two witnesses, but they could be two witnesses to completely different things. Our Constitution is the same overt act, meaning two people had to see exactly that. Or alternatively, confession in open court. If you admit it in court, that's good enough. And two witnesses to the same overt act is hard, particularly for a crime that is almost by definition committed in secret, right? You don't see people just openly committing treason out in the street, right? Particularly aiding the enemy. A lot of times this is done where you're passing, say, secrets to somebody in the middle of the night. And it's also particularly hard if you do it by a computer, in your house. Who are the two witnesses to that? So that presents a significant hurdle for any prosecutor who's thinking about doing a treason charge.
So I found myself wanting, on the one hand, to poke some more at the legal definitions, and on the other hand, to talk a little bit about why we care so much. I mean, it strikes me that maybe before we turn to the particulars, both of historical examples and kind of gaming them out to various possible present analogs, We should start with the why does it matter question, right? As I understand what you've described, the fact that some given disloyal, traitorous, if not treasonous, behavior by an American citizen doesn't rise to the level of treason as defined in the Constitution doesn't prevent that person from being prosecuted for something else. Is that right?
Yes, that's exactly right. And treason really is not our primary national security crime, right? We have a whole host of other crimes that deal with different types of disloyalty. And so probably the most familiar one would be espionage. So if you're passing military secrets not to an actual enemy in an open war, but just another country, you're passing secrets to Russia or to China or something like that, you're guilty of espionage. And I think the best example of that would be the Rosenbergs in the 1950s, passing secrets to the Soviet Union. They were not technically guilty of treason because we were formally not at war with the Soviet Union. But they were executed nonetheless on espionage charges. So in some ways you might say, well, who cares whether it's treason or not, because you can always prosecute them usually for some other crime. And that'd be true of living war too. I mean, if you're raising an army against and attacking the government, you've probably committed some other things along the way that short of that aren't treason. So does it really matter? Well, I think it actually does. And I think there's this very distinctive stigma about the crime of treason that it riles people up. People really, really, really want this to be treason. And I saw this a lot of times with respect to Donald Trump. People really, 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 really wanted Donald Trump to be guilty of treason and nothing less. And I think that sort of emotion that this crime can inspire is, one of the reasons why the framers were so concerned about it. That it really does lend itself perhaps to the most abuse, and the most abuse in sort of heightened politically divisive situations, which of course we have a lot of at the moment.
Maybe one way to think about this is to think about some historical treason trials, and you engage with the detail in your analysis is just such a joy to read. Why is the Burr trial brought as a treason prosecution rather than as some other less demanding charge that might have been equally in violation of a U.S. restriction? Why do they pursue treason rather than easier to prove crimes if there's these really difficult evidentiary requirements and there's also these very particular checkboxes that have to be ticked off before treason can be defined as even happened?
So the Aaron Burr case is very interesting. This is where Thomas Jefferson prosecuted his former vice president, Aaron Burr, for treason. The trial was held in 1807 in Richmond, Virginia. Chief Justice John Marshall presiding over the trial. And
can I pause you for one second?
Sure.
If you don't mind, I would love it if you would read your introduction to the Burr trial. It's the second page in the case of Aaron Burr. I mean, for a lot of folks, and including me, although I know the period, at least to some extent, it can get confusing to think about who's who and what's what. And you have this marvelous passage where you take the players from that era and kind of translate them into players that we all instinctively understand and know.
Sure. Yeah. Okay. So this is from page 40 of the book. Everything about the treason trial of Aaron Burr was bizarre. Consider a modern analogy. In 2012, President Barack Obama drops Joe Biden as his running mate and is reelected with a different vice president. In 2015, the Obama administration indicts Biden for treason, for trying to split the United States in half. And the trial is presided over by Chief Justice John Roberts, a bitter personal enemy and second cousin once removed of President Obama. To spice it up even further, Chief Justice Roberts' mother-in-law is President Obama's first fiancée. The prime witness against Biden in the grand jury proceedings is General Colin Powell, who's been a secret agent of the Spanish government for years. And Biden has recently killed former Treasury Secretary Robert Rubin in a duel and is under indictment for murder in New York and New Jersey. Any screenwriter who proposed this plotline would be quickly laughed out of town, as it strains the credibility of even the most ridiculous Hollywood political thriller. Yet this is precisely what transpired during the second term of President Thomas Jefferson. The Chief Justice was John Marshall, Jefferson's second cousin, once removed, and the son-in-law of Jefferson's first fiancée. The witness was General James Wilkinson, the commanding general in the American West and governor of the Louisiana Territory, who for years had been a paid agent of the Spanish government. And the former vice president, of course, was Aaron Burr, who had memorably killed former Treasury Secretary Alexander Hamilton in a duel. Chief Justice Marshall later described the Burr treason trial as the most unpleasant case which has ever been brought before a judge in this or perhaps in any other country. There's good reason to take him at his word. It remains the most extraordinary treason trial in United States history. A former vice president, the highest-ranking person ever charged with treason, ferociously prosecuted for a capital crime by the administration under which he had previously served.
So did Burr? So I just have to say that's just wonderful. In your book, the capacity in your writing and your analysis to weave together rich, engaging, like seriously academically grounded research with a pace and an exposition that is just a joy to read is really something that I tip my hat to. It's a really wonderful piece of work. Did Aaron Burr commit treason?
You know, no one knows. It's one of the great mysteries of American history. What he was doing, he was out in the American West, doing things that looked a lot like treason. The Jefferson's administration's charge was that he had assembled these men. He was going to march them to New Orleans to try to overthrow the government there and create this separate empire in the American West. On the other hand, perhaps he was just kind of dinging around and trying to raise money as a disgraced, former politician, working his marks in the American West. It's hard to know. I mean, Burr he could have done a lot of things to clear himself, and he never did. He could have made statements that would have clarified his intent, and he never did those. So I suspect he probably was up to no good. He was ultimately acquitted. Marshall's ruling made it very hard for the government to prove anything because they didn't have a good, clear, overt act of what it was Burr had supposedly done. As it appears, there was a plot, but the plot hadn't yet ripened into any actual overt act of treason.
What do you think would it be enough, or what would have been enough, right? If it was conversations and an organization and maybe some passing back and forth of money, what would have brought Burr over the line to a commission of the Dread Act at that time?
Yeah, I think he would have had to have actually had soldiers marching directly against the government. They wouldn't necessarily have had to have certainly would have had to have succeeded. And it's possible that they, even the marching absent firing weapons might have been enough. But all they had was a group of men gathering at an island in the middle of the Ohio River, Splennerhasset Island. And that gathering just wasn't enough.
Okay. Well, carrying that idea forward, what if he gathered a group of men to march on Fort Knox, or the equivalent, as part of one of the most audacious heists in the history of the United States? Same group of people, same coordination ahead of time, same sort of military force against maybe even many of the same federal agents. Is that treason?
It could be. I mean, it's an interesting question. It depends what they're trying to do. I mean, if they're just trying to steal gold from Fort Knox, I would think probably not. That looks just...
And why not? What would be different about that?
Well, I think what's different there is you're not trying to overthrow the government. All you've done is you're trying to, pilfer gold from it. I mean, so you've committed essentially a burglary or a robbery or something like that. But it doesn't seem to have the same intent of actually overthrowing the government. And the cases seem to emphasize that what really matters here is your intent. And so if you're doing it just really for sort of private motives, I mean, let's say you hated the commandant of Fort Knox because you had some personal grudge against him, so you raised some armed force to go attack him and kill him. That wouldn't be treason. But if you're trying to overthrow the fort and take it over as part of a larger scheme, then potentially it would be.
Well, what about the entire Confederacy then, right? I mean, one of the great controversies of the present moment, and not only in the present moment, has been how to think about the legacy of the Confederacy, like spoil or bad, but also the legacy of the Confederacy in a long arc tradition of memory and reconciling with the past and confronting the past and so forth. I mean, are these statues that are throughout a great number of southern towns, large and small, of of revolution, pardon me, of Civil War Confederate figures? Are these statues to treasonous Americans?
Yes, they are. I mean, the Confederacy was levying war against the United States. Under the narrowest possible definition of term. I mean, that is, it doesn't get more levying war than the Civil War, right? I mean, that's a real war. So their only argument was, well, it's not, from the Confederate perspective, it's not treason because we're an independent country, right? So we're not committing treason. We're just defending our own Confederate state. So then it turns on the issue of whether or not secession is constitutional or not. And so if secession is not constitutional, then it's clearly treason. If it is constitutional, then it's not treason. And that question of whether it's constitutional or not is largely settled by the Civil War, and it's sort of dealt with by the Supreme Court in kind of an offhand manner in an 1869 decision. But if we accept that the United States is a country that can't be simply dismembered in the way that the Confederates sought to do, then yes, they were committing treason. And Jefferson Davis was indicted for treason at the end of the war. He spent several years under indictment, ultimately escaped based in part on a sort of technicality raised under the 14th Amendment by Chief Justice Chase, and then ultimately pardoned by Andrew Johnson. And so no Confederate was actually tried for treason after the war.
How many were indicted? Was it a great many or just a handful?
There were a handful here and there. The big book on this is With Malice Toward None by Professor Blair. And he's actually found in a number of sort of archives, and a lot more indictments than people had initially thought for treason. It doesn't appear that any of those, ever went to trial, and certainly no one was executed.
All right, so we have a very big effort to dismember the country. Let's assume the most aggressive version of the Burr conspiracy is to slice off Louisiana, or the Confederacy seeks simply exit the United States. That's levying war. How about an armed militia gathers to resist the enforcement of a mask mandate? Is that treason insofar as it ends up being, let's say, persistently done in the face of military force? The National Guard comes out to seek to suppress the militia, and what's at issue here is their desire to resist a mask mandate.
If it's just resistance of a particular law, it's probably not treason. And this goes back to some judicial decisions from the early 1800s, where the lower courts had said that armed resistance to a particular law with the intent of making it inoperable was treason against the United States. But later decisions seem to have turned away from that and say that if you're just protesting one particular law, even with armed force, that's not going to be enough. So if all you're trying to do is resist a mask mandate, that's probably enough. But if you're trying to do something more, like, say, kidnap the governor and decapitate the government, then that's a very different deal. And it's not just, of course, federal law that has treason, it's state law as well. So
you're saying that potentially they could be prosecuted for treason against the state, not only against the United States.
Yeah, right. So if your folks there in Michigan who wanted to kidnap your governor, there's a decent argument that they actually, had it gone through, potentially could have been charged with treason against the state of Michigan. Michigan defines it as levying war against the state or adhering to their enemies, giving them aid and comfort. Now, they didn't actually do it. It was a conspiracy to do it. And historically, a conspiracy to levy war is not treason. You have to actually do it. And that's one of the issues in the Burr case, right? Because they potentially conspired to do it, but they hadn't actually done it. And so, same thing here with these militia members. It seems like all they had was the conspiracy, but they got them on so many other charges that a prosecutor isn't going to try to monkey up a case by throwing in a treason charge just for the heck of it, because that creates a lot of legal complications.
Does the scope of what states can define as treason, is that affected by the U.S. constitutional definition?
No. So the federal constitution limits treason against the United States, but in theory, states are free to define treason against their state in whatever manner they want. And so if they want to create a much broader definition of treason, they presumably could do that. The one thing I think they probably can't do is actually prosecute adhering to the enemies of a state, because enemies are essentially entirely an international law issue, and only the federal government can be said to have enemies in that sense. And so there was a decision from the War of 1812 that suggested that the New York couldn't really enforce an enemies provision of its treason law, that is now entirely preempted by federal law. But if you're talking about levying war against the state independent of trying to overthrow the feds, I think that the states are free to structure that law how they want.
I do want to talk at least a bit before we have a chance for some audience Q&A about the other leg of what can constitute treason, which is aid and comfort. But I was struck by your discussion of the way in which the Southern slaveholding establishment at times attempted to frame resistance to slavery, slave uprisings, the uprisings of enslaved persons, resistance to people sent to recover escaped former slaves, framed that as, at least in some sense, levying war against the system, against the state. Tell me a little bit more about some of the ways in which that kind of rhetoric, and in fact, legal charge was bandied about in the context of resistance to slavery.
Yeah, so in 1850, Congress passed a much stricter fugitive slave law, which essentially allowed Southerners to go into northern states and to recover individuals that they claimed were escaped slaves, and to do so.
So they could just go into the North
as
private citizens and seize somebody who they claimed was a former slave?
Yes, and they could then bring the person before a federal commissioner, and that person would verify whether this person was a slave or not. If they said the person was a slave, they got $10. If they said it was not a slave, they got $5. So the act itself had basically weighted the scales of justice here in favor of slavery. And so there was a very famous treason case, which was actually held in Independence Hall, on the second floor of Independence Hall, arising out of resistance to the Fugitive Slave Act, where a group of enslavers from Maryland, a man named Edward Gorsuch, who's actually a distant relative of Justice Neil Gorsuch, came into Pennsylvania, and they attempted to recover men that they claimed were their escaped slaves. And they encountered violent resistance, and Mr. Gorsuch was shot. And the people who resisted were then tried for treason against the United States, for levying war against the United States, by resisting the Fugitive Slave Act. And about 35 African Americans were brought for trial in Independence Hall. They were the only African Americans charged with treason under the U.S. Constitution. And ultimately, the judges in that case ruled that this simply didn't amount to treason, that the government could not prove here that there's any sort of larger attempt to overthrow the government. It was simply resistance to this particular law.
And that's one of the ways it sounds like in which you said that while perhaps systematic resistance to a particular law in the early republic, the Whiskey Rebellion and whatnot, might plausibly have constituted treason, we sort of narrow down what it means to levy war against the United States.
Yeah, this is one of the key precedents for that point.
Terrific. I want to talk a bit about aid and comfort, and about what constitutes aid and comfort, and about some of the ways in which one might think it starts to tread towards some First Amendment considerations and First Amendment concerns. And here I'm thinking too of non-treason wrongs, such as material support and so forth. But let's take, Jane Fonda, described as Hanoi Jane during the Vietnam War because of her cooperation with the North Vietnam government and participation in interviews that were hostile to the American war effort. If a treason prosecution was brought against her, would that have been laughed out of court, or is that the sort of thing that might take some thinking before you could reject it?
Yeah, it's definitely a close case, and so I talk about the Jane Fonda case a bit in the book, in which she was accused of doing. I mean, not really accused. I mean, she did do it. I mean, she made a number of broadcasts over Radio Hanoi, arguing that American soldiers should essentially just put down their arms and the war wasn't justified and wasn't worth fighting. Now, it turns out there were a number of cases from World War II where people have been charged with treason for doing exactly that. That is, for broadcasting propaganda on behalf of the enemy from the enemy capital. And so we had Axis Sally broadcasting from Berlin, the so-called Tokyo Rose broadcasting from Tokyo, although her case, she really, I think, got a raw deal. She really, I don't think she didn't really broadcast any anti-American propaganda at all. Axis Sally clearly did. She was quite a horrible human being. And people, defendants raised the First Amendment defense and said, well, I had a right to say whatever I want about the war. And what the courts in the 1940s said was, in the United States, that's true. You have the right to sort of criticize the government all you want, say that the war is a terrible idea, that we got into it for the wrong reasons, and so forth. But what you can't do is essentially coordinate with the enemy. You can't go be an agent for the enemy, working directly for the enemy, and broadcast that same propaganda. And that coordination makes a fundamental First Amendment difference. Now, obviously, our First Amendment law has gotten a lot broader since the 1940s in terms of things that we're willing to protect. But I think that basic distinction still holds, that it can't be the case that if you're aiding the enemy, and you're doing so primarily through words, that you get a First Amendment exemption for that. I mean, one might even think of the simple case of passing secrets to the enemy. That's done entirely with words, but I can't imagine that that's protected by the First Amendment. And the most recent indictment, actually 2006, of Adam Gadon, was of a broadcaster. He was a propagandist for Al-Qaeda, making videos against the United States and in favor of Al-Qaeda. And I think it's very hard to argue that the First Amendment protects activity like that.
So, in this vein, I'm trying to think about what aid and comfort to the enemy looks like. We've talked a bit about what might constitute aid and comfort. I also find myself wondering how we think about what constitutes the enemy. I mean, take the, let's say, challenging and increasingly challenging American relationship with China. I'm staying away from Russia for the moment. Right, in sort of contestation over a whole range of geopolitical priorities, including some encounters in the Pacific Ocean that sort of seem to come pretty close to, not shots fired, but something like real military brush-ups. If someone is transmitting confidential American military secrets to the Chinese government, have they merely committed espionage, or have they potentially also committed treason as defined by the U.S. Constitution?
Well, they've certainly committed espionage, and that's, I don't know that mere espionage is a thing. I mean, that's some pretty serious espionage.
Just a little light espionage.
Right, yeah, a little light espionage. But I don't think it's treason. We aren't simply in a state of open war with China. We have obviously a very adversarial relationship with them in some ways, but they're not an enemy. And so we think about what it would mean to really be an enemy. I mean, that would mean that Americans doing business in China potentially would be subject to treason prosecutions for aiding the enemy. Someone representing China as a representative, in the United States government, lobbying for China, that would be aiding the enemy. So being an enemy is a very big deal. I mean, I think that, that means that we see their planes, we shoot. We see their ships, we fire on them. We could round up Chinese nationals as enemy aliens here in the United States. And we don't do any of those things because we simply just aren't in that state of open war. And so even if there's, a lot of, back and forth, and they're clearly, an adversary, I think it's safe to say, but they aren't an enemy.
So we have treason. We have levying war against the United States, and we have aid and comfort to the enemy. And we have sort of a range of ways in which you've described history provides some answers and doesn't provide other answers to the application of those kinds of questions. Let me sort of wind up our back and forth before turning over to general conversation with your thoughts on the question of the hour, or maybe really the question of 8 months ago, which is to say, if you assume that the allegations against President Trump were accurate in terms of his solicitation of support and the trading of favors in exchange for the support from the government of Russia, both before he became president and during his presidency. Imagine that's all true. I'm interested in the legal question. I know you are too. Does that constitute treason, or is it silly for us even to talk in those terms?
Well, I certainly understand why people immediately jump to the T word, when they hear those types of claims. The idea that the United States president might potentially be compromised by Russia or working for Russia in some fashion is really something that we've never dealt with as a country. And so if you assume that that's true, and I don't have any particular knowledge of whether it's true or not, but if we assume that it is true, I still think it's not treason. Again, for the same reason, if China's not an enemy, Russia isn't technically an enemy either. Now, that doesn't mean it's okay.
Sorry, one quick question. Does it require a declaration of war or, the requisite sort of authorization for hostilities in a formal sense?
No, it doesn't require a formal declaration of war, because you can have a state of open war even if there's no declaration of war. And you can think, the Korean War was no less a war for not being declared. The Vietnam War was still a war. And I think, something like Al-Qaeda, you have the AUMF, the Authorization of Use of Military Force. I think that's clearly sufficient to create a state of war between us and Al-Qaeda. But what we do need to have is some clear declaration from the political departments that we are effectively in a state of war with this group. So the citizens are on notice that this country is now off limits. Right, and so a lot of people say, Russia really is an enemy because of this reason or that reason. Well, it's not up to just random people to decide who's an enemy, right? This is the single most significant foreign policy decision a government can possibly make. And so it has to be backed up, just as a matter of sort of basic due process, with some declaration from the federal government that gives evidence that we actually are in a state of war. And so something like ISIS, when you have Obama announcing 14,000 bombings of ISIS positions, well, that's pretty clear. That's not something we do to our friends. This is an enemy.
Well, Carlton, this book is so rich and so fascinating. I have so many more questions, but I want to be respectful of the fact that many in the audience do as well, I'm quite sure. And so, John, perhaps you could take over the audience Q&A portion.
Absolutely. We don't have any questions just yet, so I want to take this opportunity to remind all of our attendees that they can use the Q&A feature at the bottom of their screen or at the top, I think, if you're using a Mac, the toolbar's oriented differently. You can use that to submit a question at any time. So any question you have about the book, or perhaps more broadly about the theory behind it and the law behind it, feel free to submit that question. But Julian, not to just immediately bounce it back to you, but if there's anything you didn't get a chance to ask Carlton while our audience stews on some questions, please feel free, and I'll come back on when we've got some questions.
I'd be delighted to, and Carlton and I may keep talking even after the event ends, because I have so many questions. Again, everybody buy this book, read this book. It's a spectacular book. I'd be interested in getting your perspective, thinking like moving forward as a prosecutor in the federal government. Under what circumstances would you charge treason? If you can effectively get the same kind of penalties from charges that are less difficult to prove, is treason at this point nothing more than an epithet on the one hand and then a legal relic on the other hand, or does it still at least potentially play some role in our legal ecosystem?
Yeah, I think it does have some role. I honestly don't think you're going to see many levying of war cases. Now, in theory, you could. For example, I do think the bombing of the Oklahoma City federal building could be viewed as an act of levying war against the United States. That was probably undermined by they didn't have two witnesses to the same overt act. Again, that just becomes a problem, in terms of making that charge stick. Certainly, aid to some of these foreign terrorist groups could be prosecuted as treason. And so it was actually interesting, the 2006 indictment of Adam Gadon, that was the first treason indictment in the United States since the early 1950s, which was sort of cleaning up.
Tell us a little more about him, about what he was accused of having done.
So Adam Gadon, it's a very fascinating story. This was a guy who grew up on sort of a goat farm in Riverside County, California, and then moved to the LA area to live with his grandparents, and then converted to Islam and became radicalized by people with connections to Al-Qaeda, and then ultimately moved and spent the rest of his life in Pakistan and Afghanistan. And because he had English language skills, he was very useful to them as a propagandist in making videos. So in 2006, he is indicted for treason against the United States for aiding the enemy. And in doing so, the Department of Justice essentially was making it clear that Al-Qaeda is an enemy for purposes of the treason charge. And so this is the first treason indictment in American history where it's not a nation state with whom we're actually in a declared war. All the others have been that for aiding the enemy. So that was important as a legal milestone. Now, what happened was Gaddafi was killed in a drone strike, and so he was never actually prosecuted, and he wasn't brought back to the United States. Had he been captured, he could have been brought back, and we would have then had, the first treason trial in 50-some years here on American soil, and that would have been very interesting. And I assume he would have raised various arguments. Now, the Justice Department insisted that they had two witnesses to the same overt act here, but I'm not actually sure that they did, because think about what Gaddafi was charged with, which was basically sitting in a room recording these videos on a computer. I mean, did they really have the sort of percipient witnesses who were physically present and said that he did this? That's a tough charge, and it's probably not enough under the two-witness requirement just to have the video evidence itself. And so I think any Gaddafi prosecution probably would have had a bit of a struggle, given that two-witness issue.
I see John coming back on, and I see some great questions that are popping up in the Q&A.
We do have some audience questions. The first one from Shannon: can treason be pardoned? Do you think that, for instance, Biden would pardon President Trump with President-elect Biden would pardon President Trump with similar motivations that Ford pardoned Nixon?
So yes, treason can be pardoned. Our earliest presidents granted pardons for treason. So George Washington pardoned people who had been convicted in the Whiskey Rebellion. John Adams pardoned people who had been convicted in Freeze's Rebellion. And in some ways, the post-Civil War, the amnesty proclamations by President Johnson were effectively pardons of any person who had committed treason during the Civil War. As to what a President Biden would do with respect to President Trump, I mean, your guess is as good as mine. I don't have any particular insight into Biden's thinking on that point. It would, yeah, I mean, it raises the same issues I think that it did for President Ford. The question of sort of strict justice for criminals versus avoiding things that might make someone into more of a martyr. And that was part of the concern actually with Jefferson Davis. From the Northern perspective, he was clearly a criminal. He was clearly a traitor, and he resulted in thousands of people dying. He should have been hung. But from the perspective of going forward as a nation, making Jefferson Davis a martyr in some ways elevates him even more in the Southern mind than does letting him go. So I think those are very difficult questions.
Brian asks, was aid and comfort an 18th century term of art? If so, what did it mean then? Does it necessarily mean something more than just giving aid?
It does appear to be an 18th century a term of art because it comes out of the 1351 English Statute of Treasons. I actually had a bit of trouble finding really precise definitions of what aid and comfort meant. And this resulted in actually a fairly close decision of the U.S. Supreme Court in 1945, in the case of Kramer versus United States. And this involved Nazi saboteurs who had come into the country, and they met up with a person here who aided them. And he had met them in a bar, drank with them, and then later took some of their money and stored it. And he knew that they were Nazi saboteurs. And the government presented evidence of the meeting for drinks. They had two witnesses to the meeting for drinks, but they didn't have two witnesses to the money belt. And so the question was, is this sufficient to establish treason by aiding the enemy when all he was doing was drinking with them? And 5 justices in the Supreme Court said, no, that's not enough. The drinking in itself doesn't actually aid the enemy. If anything, it was probably a distraction. But because, 4 justices in dissent said, well, this was clearly part of a larger pattern. They were, involved with this enemy agent, and that would be enough. So the controlling opinion, though, makes this pretty tough. That the aid and comfort you give has to sort of directly advance the enemy's war effort, and so it can't just be some minor thing. Certainly not buying the agent a drink.
There's another question as well about aid and comfort. Carlton, from your college classmate Chris, who asks, is aid and comfort to a domestic terrorist considered treason?
It wouldn't be treason by aiding the enemy, because a domestic terrorist, by definition, is not an enemy for purposes of the treason clause. If the domestic terrorist was levying war against the United States, and this person was involved in that in some manner, then it potentially could be charged as a case of levying war. But it couldn't be aiding the enemy, because enemies have to be foreign groups. A domestic group cannot be an enemy.
And finally, I have a question from Andrew. Any insights from a comparative law perspective as to how U.S. treason law compares to other countries?
Well, I know very little about the treason laws of other countries. Probably the one I know closest is Britain, which has many things that are similar to our treason law. But what I do think is distinctive, what we can say is distinctive, is the actual constitutional definition, and how that has sort of been the anchor of our treason law for now nearing 230 years. In most countries, you can simply change the treason law by statute. You can update it as needs be, whereas we can't do that. I mean, we are kind of locked into this 18th century definition, and short of amending our Constitution, there's not much we can do about it. So I think that makes us distinctive, and I think that's sort of a general example of American life being distinctive, in that we are locked into 18th century ways of doing things. I mean, just think about, we are locking in our president based on an electoral college, which is this 18th century institution.
Thank you. We've got a bit of time. Julian, if you had any final questions you wanted to ask Carlton before we go.
Yeah, I suppose a place to land might be, as you described, again, wonderful detail in the book, one of the reasons to worry about treason at the founding was some of the consequences that came with it in terms of forfeiture that went with your descendants and so forth. And yet, as you also trace, it remains a really highly salient, really emotionally resonant claim to make about someone. And I'm wondering if you could just maybe wind us up with some reflections on why. What is treason about? Why does it loom so large for us? We've spent lots of time going back and forth between particular stories and the elements of the crime and where they're satisfied and where they're not. Stepping back from all of it, why is treason still such a resonant charge to throw against somebody who you are accusing of having done bad things? And should it be?
Well, I think a person viewed as a traitor is sort of seen as sort of fundamentally un-American, right? That that you have violated, in some ways, your deepest loyalty, right? You have gone over to the other side, and that there's something really despicable about that. That certainly makes it different from a range of other crimes. That said, it is also a uniquely political crime. And we often think about criminal law as just violent offenses, and then various sort of white collar offenses. This one is actually quite different. And if you think about the people charged with they range all kinds of people in American history, from a former vice president like Aaron Burr, down to very ordinary people, and of course Jefferson Davis, a former U.S. cabinet member, former U.S. senator. So it's a crime that doesn't fit any social profile. But it's also, and I found this in my book with the American Revolution, it's a crime that people, weirdly enough, despite all of the intensity and rhetoric about it, it's a crime that people are willing to forgive. And what you saw in the American Revolution was all kinds of people who had aided the British, but they were unable to be convicted by juries, and they ultimately were able to come back and be welcomed back into American society. And you think about the Civil War. Essentially, the Confederates were forgiven for the crime of treason. And that's not true of a number of other crimes. We don't forgive murders, generally, in this country. We don't forgive violent assaults. But treason often has been. And so I think it's just a very distinctive type of crime, and it raises a whole range of sort of distinct emotional responses in people in terms of how they initially react to it and then what they ultimately want done with it.
Thank you so much, Carlton. This has been terrific. For my part, I'm so pleased to have had a chance to talk through these things with you. As I've said, I couldn't recommend the book highly enough, and I'm just grateful for the chance to talk it through.
Thank you both for being here. Folks can purchase the book at the links in the chat. And of course, if you're watching us later on YouTube, there are links in the description below as well. Carlton F.W. Larson, Julian Mortenson, thank you so much for joining us this evening on At Home with Literati. We hope to have you in Ann Arbor when we're on the other side of all of this stuff. But until that time, please continue to stay safe and be well. And to all of our attendees, thank you for joining us this evening. And we hope to see you at the next event. And please continue to be safe and take care as well. And good night, all.
Thank you.